Good afternoon, everyone. Morning, evening. I can see we have people from all over the world joining us today. We are so grateful for all of you for logging on for what I'm certain is going to be a really robust and enlightening discussion. I'm Michael Clements, the Director for International Programs at the Business and Human Rights Resource Center. And together with our partners, the Center for Applied Legal Studies, Justica Ambiental, the International Commission of Jurists, Lawyers for Human Rights, and ZELA, we are delighted to welcome all of you to the first of 3 webinars in our series, Bridging the Gap, a Stronger Binding Treaty for All. Very briefly, the series really aims over the course of the next 3 months as we lead up to the 9th round of treaty negotiations to do a few things. First, to explore some of the thornier issues related to the proposed treaty, particularly as it's evolved over the course of the years. Second, to amplify and relay the messages of communities, workers, and civil society that have together helped shape this instrument and ensure continued momentum behind it. And then third, to highlight some of the gaps that persist in the current text and process and require addressing if the final version of the treaty is to matter meaningfully for those it's envisioned to protect. So namely frontline communities, including indigenous communities and human rights defenders who have historically borne the brunt of poor human rights practice by business. As I'm sure most on this call will know, the binding treaty process has been underway since 2014, the product of a resolution adopted by the Human Rights Council and put forward by Ecuador and South Africa. An open-ended intergovernmental working group chaired by Ecuador was then established with the mandate to elaborate an international legally binding instrument on transnational corporations and other business enterprises with respect to human rights. And I still have to read that after all these years. The negotiation process since then, as you'll all also know, has resulted in a number of iterations of the treaty text debated each year in Geneva, and culminating last year in discussion on a 3rd revised text supplemented by specific textual proposals by states, as well as a series of proposals to amend specific articles in the current text put forward by the chair of the Intergovernmental Working Group. Now, of real importance over the course of this nearly 10-year process has been the role that civil society, and particularly civil society of the Global South, has played in driving it. And I think it's in many ways thanks to those efforts by civil society that this process has so far survived strong opposition from some states, unhelpfully limited engagement by others, and robust statements of resistance each year by certain industry groups. But as Professor Suryadeva, former member of the UN Working Group on Business and Human Rights and current Special Rapporteur on the Right to Development, has reflected, the treaty process itself has put the need for adopting binding rules that locate human rights more centrally within corporate activity on the top shelf. And as we sit here today, we are witnessing real momentum behind a range of efforts to strengthen regulatory oversight of companies and investors through due diligence initiatives, through supply chain transparency acts, and through regulation like import bans around the world. The release of the EU's Corporate Sustainability Due Diligence Directive last February and the subsequent process over the course of this year to finalize its text represents one example of crucial progress in mandating respect for human rights by at least EU operating businesses whose impact is of course felt around the world. And it's for that reason that the EU initiative often gets a lot of airtime in these discussions. But other jurisdictions have also made real policy strides in this respect, including individual EU countries, of course, Japan, but also Brazil, Colombia, Mexico, Korea, as well as the African Commission's recent notable resolution focused on developing regional policy that ensures accountability and access to remedy for business-related human rights harms in Africa, with a particular focus, an explicit focus on marginalized and vulnerable populations. And what we're starting to see are communities and CSOs beginning to test the robustness of the promise of remedy that some of these enacted regulations offer through court challenges. And more of that to come, I'm sure. These advancements together, I think, represent real opportunity for continued transformation of what we know today to be the dominant business model that solely pursues profit, and for the short-termism by investors that has long had severe impact for people and planet. In this context, and of real importance, we're for the first time seeing many corporations and investors expressing support, publicly expressing support for approaches like mandatory human rights due diligence, which is the core in many ways of the proposed treaty and much of this new legislation. And that would have been unthinkable at the start of the treaty process and even up to a few years ago. But it's clear that stakeholder groups of many stripes are beginning to see the writing on the wall, to decided global acknowledgement that voluntary initiatives to protect human rights from business have simply not worked well enough. And as a result, we're seeing a clear new openness to models of active government to redirect markets to shared prosperity and climate security, worker and community empowerment, and business regulation and incentives to enhance corporate accountability. Now, looking at the world as it stands today, this isn't a moment too soon. We're seeing marginalized populations and workers growing ever more vulnerable. We're witnessing an increasingly challenging global economy with soaring inflation and a resultant cost of living crisis, global conflict and deepening regional crises, the need for an urgent global transition to renewable energy to avert climate catastrophe in a way that ensures shared prosperity, justice, and human rights protections, and the need for more accountable technology given the rapid growth of AI, spyware, and mass misinformation campaigns that have direct impact on vulnerable communities, human rights defenders, and others. Against that background, today we'll explore the crucial question of the complementarity of the range of initiatives that are emerging in number to address these converging crises. So the treaty, together with national action plans, together with various pieces of legislation, which together seem to suggest a new moment for the business and human rights movement, for corporate accountability, and for transparency. And we'll hear from these experts shortly about the roles of these various approaches and the ways in which they can work together to augment human rights protection of the most vulnerable in the context of business. But certainly one common thread between these approaches is that the rights holders who are the intended beneficiaries of these initiatives have to play a robust role in shaping them and monitoring them if they're to be truly responsive to the lived experiences and needs of, for example, the communities across the world that are still being asked to host large mining projects, indigenous communities safeguarding their right to free, prior, and informed consent, human rights defenders falling victim to unscrupulous use of technology, workers toiling in abhorrent conditions, and for poverty wages, just to name a few. Continuous, robust engagement and consultation with rights holders and their representatives, combined with access to real remedy when things go wrong, have to be core to all of these initiatives if they're to live up to the promise that they seem to offer. And these are some of the core demands of the broad range of communities and civil society organizations that have spearheaded advocacy around the treaty for years. There is sustained engagement. Claiming and holding space in the treaty process is an important model for other initiatives and a role that has to continue to be safeguarded by the Intergovernmental Working Group, as well as states as the treaty process evolves. Thanks again to everyone for joining us today. And with that, I'm going to hand over to Jessica Lawrence, the head of the Environmental Rights Program at Lawyers for Human Rights, to moderate our panel discussion. And my colleague Elodie Abba will then facilitate Q&A. Jessica, over to you.
Thank you, Michael. Hello, everyone. It is a great pleasure to be here today. I would like to introduce our speakers that will share their insights with us today. Unfortunately, two of our speakers are unable to join us. Commissioner Derso of the African Commission on Human and People's Rights told us this morning that he was unable to join. And unfortunately, Arnold Kwesiga is stuck in transit. But we will hear from our three speakers. And today we are joined by Joseph Purugganan, who is the head of the Philippine Office of Focus of the Global South, a progressive policy research and campaign organization working on the themes of political economy, of development, people's alternatives, power and democracy, climate and gender justice. He spearheads Focus's work on trade and investment and corporate accountability. He is also one of the conveners of Asian Task Force on the Binding Treaty. We were also joined by Andressa Suarez, who is the General Coordinator at HOMA, Center for Human Rights and Business in Brazil. She is a jurist and lawyer and is currently doing her PhD in international law at the University of Sao Paulo. She was also a visiting professional at the Inter-American Court on Human Rights. Our final speaker will be Giuseppe Cioffo, who works as the Corporate Regulation Officer for CIDSE, the International Family of Catholic Social Justice Organizations. He advocates for binding laws to regulate corporate impacts on human rights and the environment, both at the EU and the UN level. He has been participating in the UN negotiation sessions on the binding treaty on transnational corporations and advocating for access to justice and remedy in the corporate sustainability due diligence directives in the EU. Before we start, I would like to specify that the webinar will consist of each speaker sharing their reflections on a specific topic. At the end, we will have the opportunity for each of our attendees to ask questions. You will be able to do so by raising your hand on the Zoom platform. You won't be on camera, or you're able to write your question in the Q&A box. We ask that you please don't write your questions in the chat box, but rather make use of the Q&A function, as this will allow all questions to be centralized. We ask that you please keep your questions concise and clear, and that you direct your questions to a specific speaker. I am now going to hand over to Joseph Purugganan, who is going to share with us perspectives of civil society in Southeast Asia and case studies that would show the usefulness and the necessity of a treaty.
Thank you, Jessica. Hello, everybody. Good afternoon and good evening from the Philippines. Thank you to Business and Human Rights Resource Center for organizing this series of roundtables and for giving us the opportunity to share perspectives from our region on the necessity and the urgency of a legally binding instrument. In 2014, trade and anti-mining campaigners in the Philippines picketed the Office of the Department of Foreign Affairs in Manila to call on our government to support what would become UN Human Rights Council Resolution 26-9/9, mandating the elaboration of an international legally binding instrument to regulate in international human rights law the activities of transnational corporations and other business enterprises. In 2017, together with fellow campaigners from Indonesia, we launched the Asia Task Force on the LBI. ATF is envisioned to be the regional articulation of the global campaign for the LBI. The starting point of this regional articulation is the affirmative votes cast by 6 Asian states: China, India, Pakistan, the Philippines, Vietnam, and Indonesia, in support of Resolution 26-9 in June 2014. The support for the resolution for stronger binding rules for TNCs sent a strong message that states not only recognize that a gap exists in international human rights law with respect to regulating the operations of TNCs, but that there is an urgent need, and perhaps more importantly, a commitment on their part to bridge this gap. Indonesia's support, for example, could have been motivated by its desire to even the power asymmetry, having been faced with legal claims put forward by huge mining corporations before investment tribunals in the years prior to the UNHRC vote. An important motivation could be the realization that this one-way street where corporations can sue governments challenging regulations and policies, but governments cannot, or there's no other way around. No? Governments cannot sue or cannot go after these corporations. In a statement in 2015, the Indonesian representative referred to the LBI process that was just launched as a new phase, quote, of our common endeavor with regards to human rights protection and promotion, end quote. Aside from understanding the motivations of states that supported the resolution, sustaining the pressure to continue this process requires a much deeper understanding of the context and dynamics at national, regional, and global levels. It is important, for example, to situate the role of Asia in the larger context of global development. especially in light of the pandemic and the economic slowdown, and the overwhelming consensus among Asian states to push for corporate-driven recovery. Sustaining the campaign is particularly challenging in Asia for a number of factors. One, Asia is at the center of growth and development. It is a hub of mega free trade agreements and investment agreements. It is where economic policies are generally pro-corporate, easing restrictions, providing more incentives, greater investor protection, and where the direction of regulations is towards liberalization. Two, we are also seeing huge negative impacts of corporations on the environment, on human rights, and specific impacts on women and gender. And all of these violations and abuses are happening alongside the steady rise of corporate power. There's also a political factor, looking at the impact of elections, for example, on state position vis-a-vis the UN and the negotiations themselves. As our experience in the Philippines has shown, it was a very different engagement in 2014 compared to 2016 onwards under the Duterte administration, not only in terms of how the administration viewed the issues and with regards to corporations and human rights, but on the whole UN and what international cooperation and diplomacy or foreign policy should look like, including on the issue of shifting alliances. It is important as well to link the LBI and corporate accountability campaigns and other campaigns like those resisting free trade agreements and so-called economic cooperation frameworks and issues related to climate and environmental justice. In Asia, the development agenda is underpinned by a continuing adherence to pro-corporate neoliberal development framework. Furthermore, we also need to be mindful of the democracy and human rights challenge in Asia, with rising authoritarianism, continuing internal wars and conflicts, and counterinsurgency, and the relentless attacks against human rights defenders. We are seeing and documenting continuing cases of human rights violations, criminalization of land and environment, and indigenous people's rights defenders, and the weaponization of law, for example, through the use of strategic lawsuits against public participation or SLAPP suits. So the question of necessity must be viewed from this very challenging vantage point. It is important to examine two interconnected realities. On the one hand, you have the reality of rising number of human rights abuses happening under authoritarian regimes. And on the other hand, you see increasing power of corporations and the capture of economic policies. The focus on TNCs in the scope of the treaty reflected clearly in the mandate of the resolution and an important demand of the global campaign, which is included in its 14-point frontiers for an effective treaty, strikes at the heart of the international legal challenge. In many cases, the most powerful actors in the entire business operations along the supply chain, the ones that profit the most from the entire operations, often bear the least liability if they are held to account at all. Most often than not, in fact, their very size is their excuse, allowing them to downplay their role in the commission of crimes and the harm inflicted on communities. Most often, when faced with cases of abuse and violations, TNCs hide behind the nature of business relationships and the people that run these corporations behind a corporate veil. Take the case of around 60 employees working as drivers and helpers illegally dismissed by Coca-Cola Bottlers Philippines, or CCBPI. The dismissed workers sought relief from the labor court in the Philippines, the National Labor Relations Commission, arguing that they are employees of the Coca-Cola company. The corporation, however, argued that they are merely contractors and showed proof of contracts between CCBPI and a company called Concepcion Lines and Freight Services, which state that Concepcion Lines will provide hauling and related services to the CCBPI. On the basis of these so-called subcontracting agreements, the court ruled in favor of the corporation. The workers went up to the Court of Appeals but were forced to settle, since by then the simple case of illegal dismissal had taken almost 3 years already. They got a pittance compared to what they deserve under Philippine law, which is full back wages and reinstatement to their former positions, and they would have had the right to go all the way to the Supreme Court. In the Philippines, illegal dismissal cases can go up to 7 years or more. Centro, the progressive labor center that supported the case of the dismissed workers, asserts that the only way the workers could have obtained full redress for their grievances would have been to file a case against Coca-Cola headquarters in Atlanta if there was an LBI on TNCs. Another case is that of communities in Kokong province in Cambodia, documented and supported by the group Equitable Cambodia. The communities alleged that their farms were damaged and their cattle killed as land was cleared to make way for sugarcane plantation under 2 economic land concessions formed by a consortium of actors, including wealthy Cambodian business tycoon, KSL Group of Thailand, and other small stakeholders. In 2010, Tate and Lyle Sugar Corporation received its first shipment of raw sugar from KSL, with which it had signed a 5-year contract to purchase all of its sugar output from Cambodia and Laos. In 2012, NGO partners lodged a complaint with the OECD National Contact Point of the United States, alleging breaches of the OECD guidelines for multinational enterprises against the parent company of Tate and Lyle, American Sugar Refining Incorporated. In 2013, NGO partner Community Legal Education Center contacted an English law firm on behalf of affected families in Kokong to initiate legal action against Tate and Lyle, claiming that the UK company knew or should have known of the allegations against its suppliers. They demanded compensation for the value of sugar grown on land they allege still belongs to them. The claim was filed in March 2013. The community entered into settlement discussions with the company in 2015, but after years of negotiations, the company simply refused to pay compensation and instead vows to, quote, continue to use any leverage it had to ensure the villagers receive financial compensation from KSL and its ex-business partner. In these cases, the affected communities seek remedy and justice, not just from the local perpetrators, but the mother companies, the big brands, the transnational corporations, whose business operations depend or are reliant on these services. In the case of Kokong, for example, Tate and Lyle had been exclusive beneficiaries of the sugar produced on the land for a number of years and were involved in the plantation from an early stage. They should therefore be held liable for harm done in the course of the business operations. Another important frontier for an effective treaty that is important to underscore is the principle of joint and several liability. The Global Campaign asserts that, quote, the inclusion of actors up and downstream of the chain is essential to break the logic whereby social, environmental, and economic responsibilities are externalized along TNC chains and hidden behind the corporate veil. The Global Campaign asserts further that an effective treaty must set a comprehensive and adequate framework of criminal, civil, and administrative legal liability that must be joint and several. Each and all the parties can be then held individually responsible for the entire obligation as well as for a portion of it. Overall, joint and several liability along the value chain serves as a mechanism to ensure that all parties involved in a particular human rights and environmental violation are held accountable for any harm caused and that adequate remedy is provided to the affected communities and individuals. The question of complementarity of existing mechanisms dealing with business and human rights is an important yet quite challenging issue to discuss. Do we define complementarity as it relates to jurisdiction, like in the case of the International Criminal Court, where the court can only exercise jurisdiction when national legal systems fail to do so, when it is demonstrated that they are unwilling or unable to genuinely carry out proceedings? There is an agenda being pushed in the treaty negotiations for this view, both in terms of repeated references to the prerogative and supremacy of domestic law, as well as on the question of jurisdiction and the need for an international tribunal. As the Frontiers document assert, quote, regarding access to jurisdiction, it is essential to reject unconditionally the general principle of forum non-convenience and to defend the use of the principle of forum necessitatis. The reality on the ground is that communities affected by PNCs have barely the resources to pursue legal justice at all, let alone to choose more favorable courts. Forum shopping is typical of PNCs, not of peoples affected by their violations. Or do we view complementarity as referring to different but useful when combined? On the issue of seeking corporate accountability, it can be argued that greater accountability can be achieved from a combination of voluntary, mandatory, and legally binding instruments and mechanisms. It is important to underscore, however, that in fact, this notion of complementarity of various mechanisms was challenged not by the proponents of the treaty, but rather by its strongest opponents, those who oppose Resolution 269 and continue to argue against the process are the ones who are pitting these measures against one another. They argue against the necessity and urgency of the LBI by insisting that what is needed is simply to make the UNGPs work. Complementarity should be about seeking the strongest form of accountability and not about settling for less or what is acceptable to business. Complementarity should be viewed from the perspective of affected communities and not businesses. For example, while the push for mandatory due diligence laws at the national level can be seen as an advancement to the purely voluntary nature of BHR commitments, due diligence cannot and should not be the end goal. Accountability should not be a box-ticking exercise. Long-term goals and outcomes should be accountability and justice for victims and affected communities. Finally, as campaigners pushing for the LBI, we say that the treaty is urgent and necessary. And while it is difficult and wrought with many challenges and barriers, it is not impossible. And the openness to discuss ways to strengthen the movement for greater corporate accountability through such forums like this are important steps in hurdling these barriers, confronting the corporate bias, and tilting the balance in international human rights law in favor of affected communities. Thank you.
Thank you very much, Joseph. I am now going to hand over to our next speaker, Andressa, who is going to speak to us about the framework law that regulates transnational corporations in Brazil. Over to you.
Thank you, Jessica. Thank you for the invitation. I'm really glad to be speaking in this event, in this seminar, along with these panelists. I've met Joseph during my participation in Geneva for the past years in the global campaign. As you may know, OMA, a Human Rights and Business Institute in Brazil, it has been participating in the negotiation sessions since the beginning. And me personally, I've been participating since 2019. And now, as you may know also, Manuela Roland, that was our general coordinator, she went to the Ministry of Human Rights in Brazil. She took a post there to develop Brazilian public policy on business and human rights, which really honor us. So I took the difficult task of assuming the job of becoming the general coordinator for the center. And I'm glad to be able to speak here about our framework law, because this is a job done collectively in Brazil, along with civil society and many social movements. And also, this is a result of our treaty, our work in the treaty and the negotiation process as well. I didn't prepare like a presentation that formally. I prefer to speak with improvise. This is a professor habit, but I do have problems with time. So let me know if I pass my time, because I do have problems with that. Another professor habit, I love to talk. So I love talking a lot. So how the framework law works and what is the context of that? As I said before, we've been working with the treaty process since 2014, since its beginning, along with the approval of the resolution. OMA exists since 2012. And from that moment, we started working in two fronts, in the international agenda and in the national agenda. OMA has always believed in the complementarity between these two paths. So we've always believed that we have to work internationally because we have gaps, especially with transnational corporations, that we cannot reach within domestic legislations. But we do believe that we have also work to be done internally, and that binding regulations and domestic binding regulations can really help as well to build this path of diminishing or mitigating these gaps of the transnational corporations impunity that we have. We started domestically working with, in Brazil, we formed what we call the GT Corporações, GT Corporations, what is a working group. And this started in 2013. And they started to build a public policy based on what civil society wanted. And in this period, a lot of the discussion was about the national action plans. We at ALMA didn't we don't actually believe in national action plans. It's not that we disregard completely. We do believe that some plans could have interesting results, but with the first plans, when the first plans came out, especially Latin America plans in Chile, Mexico, and Colombia, etc., we could perceive that they were not improving our framework, in the sense they were below a lot of legislations that we already had in our countries. As you may know, our constitutions in Latin America are really protective constitutions regarding human rights and collective rights. We have a model that is called neo-constitutionalism, and these constitutions are really protective. And sometimes these national action plans, they were even below these constitutions and even below the legislation that we already had in our countries. So it was not a matter of legislation only. It was a matter of effectivating or applying the legislation that we already had, because there were other things that were implied, like problems with jurisdiction, as Joseph mentioned. We had the law, but we couldn't apply the jurisdiction, or there were problems with corporate capture. We had the law, we had the jurisdiction, but we could not apply the law because the judicial power was captured by corporations, etc. And in Brazil, we saw that a lot. We're supposed to have one of the most protective legislations regarding environmental rights, for instance, and it was not sufficient or enough to protect people and communities from the rupture of the dam into 2015 from Samarco. I'm sure you all heard of it. It was a really landmark for Brazil. We've talked about human rights violation by TNCs, but this was like this landmark in 2015 that we said in Brazil, we need to go forward with this, because although we have a protective constitution, although we have a strong labor legislation, although we're supposed to have a strong environmental legislation, this is not enough. So what's happening? We have to understand what's happening. So that's why in NOMA, we've always advocated for the international treaty as well. But internally, we were able to observe that there were some problems with corporate capture. There were problems that every time the violations were made by companies or TNCs, the judicial power or the judges, they did not judge that as a matter of human rights. They usually saw that as a matter of investments, or in the sense that this is a problem of development and we cannot punish the company because this is going to jeopardize development, this is going to jeopardize jobs, etc., etc. So this always was a problem for accountability and for liability in general. So we decided that we needed something stronger than just an app. So civil society started to work on this what would be the public policy. But then we faced very dark years in politics. As you may know, we had the soft coup, and then we had in 2018, we had a decree that came completely without any consultation with civil society, that was made by Michel Temer at the time, the president, that was Dilma's vice president and was a part of the soft coup, as we say. And he took over and he presented this decree that were really, this decree was really soft in the sense that was not binding, and it was pretty much a copy and paste of the guiding principles, and even worse. So it was done without any consultation with this group of the civil society that had been formed in the 2013. So it was terrible, and the civil society responded with a resolution that was not binding at the time, but it was the first response that we had, and it was resolution number 5 done in the National Council of Human Rights, that is a civil society participation council. And OMA participated in the draft of this resolution. And a lot of that, what we put in the resolution, it was the text that as the global campaign, we participated in drafting what would be the ideal treaty. So it was like complementarity process, because we've learned what we would want in the treaty, and then we apply that for what would be ideal for the Brazilian reality. And this worked really well. And then a year later, OMA did a study that we observed that the judge, although we had these legislations and we had some institutes that were really interested, like the reversal burden proof and other things that we could apply that we asked for in the binding treaty, but we had in the Brazilian legislation already, and we could apply that, but we didn't in cases of human rights violation by companies. So we decided that we need this framework law. And we decided that for Brazilian reality, and especially for Latin American reality, this could not be just a due diligence law, because due diligence, it's an obligation of means, is not an obligation of results. So we decided that due diligence is just one of the instruments that we can use to prevent human rights violations, but we needed more. other instruments that we could profit from the discussion of the treaty, and other learnings from the cases in Brazil as well, because after Samarco case, we had the Brumadinho case as well in 2019, other rupture that killed 300 people. So we had these two big cases in Brazil, and the social movements had a lot of learnings in this period. So we decided that we need much more than just due diligence. In this framework law, we have due diligence, but due diligence is just one instrument. We have other prevent measures instruments, and we have also accountability and liability, civil and administrative liability measures, because usually in due diligence legislation, of course, we now have the European legislation that Giuseppe is going to talk about, but at OMA as well, we did a study about the German due diligence legislation, and although there are a few interesting things about it, one really bad thing, for instance, is that it does not imply directly civil liability in not fulfilling the requirements or in not complying with the obligations. So due diligence could become, if we do not take care of it, could become like a checkbox that companies use to check and say, okay, I've done all of this, so I cannot be liable, or I cannot respond for these violations because I've done all of this, what should be done. So in order to avoid that in Brazil, we decided that we needed more like a broader legislation, and that is why we call a framework legislation on a framework law. And we've worked on this really hard with a lot of civil society groups, and along with this working group in Brazil. And we've built this law based on the resolution that I've said before, and a lot based on the treaty discussions that we've had, and thinking a lot of that this could be a good complementarity, because we've had a discussion with Brazilian foreign minister, and we've said Brazil is having a posture in the negotiation sessions that Brazil is negotiating below of its own standards. So this is common because, you know, Brazil has a little bit of a mixture posture, because it's a South country. So it suffers from TNCs that comes from that come from other countries, but Brazil has their own its own TNCs. So Brazil has like a little bit of a mixture posture. So we've discussed that with Foreign Affairs, and we've said, your guys are negotiating below the standards that we have. This is unacceptable. So you cannot go to Human Rights Council and say, we cannot have like a criminal responsibility or criminal liability for legal persons, if we do have this in Brazil, because we do. So we cannot have this kind of contradiction. So we thought that this framework law, and when we put together the instruments or the legislations, and the good part of the legislations, the Brazilian legislation that we already have, along with some new things, like this is the first law that says that human rights agreements and human rights treaty have primacy along investment treaties, or this is the first law that puts the centrality of the victim's suffering. This develops some guidelines for the Convention 169 consultations. So this brings, this framework brings some novelties, but it recovers a lot of what we have in our sparse legislation and puts all together in one diploma, in one legislation that says human rights and business legislation. This facilitates for people to access to justice, for litigators to access just one law and said, no, it's all written here, and facilitates as well for civil society to say, Brazil, you have to negotiate to treat in the treaty process from this to above. You cannot negotiate below this. So this really helps in this process of complementarity, because we know that this framework is not going to solve all the problems, because we have some problems and some gaps that have to be solved in the global level, but this really helps in this process. And just to finalize, because I see that Jessica is saying that my time is finishing, just for you to know how it's going to be now. We've protocoled this bill. Is now a bill, it's not already approved. But we are creating a lot of public interest. Is interesting about it. We are just doing webinars in Brazil. I've done like 5 this semester about the framework Brazilian law. We are incentivizing other countries to create their own framework laws as well. And in Brazil, we are creating a lot of public interest in that as well. So the approval is not going to be easy. We have now a more progressive government, but still we have a very conservative Congress. But still we are working really hard on advocacy issues, etc. And with Manuela on the government and other allies that we have there, we are hoping that we can approve at least the most important parts of the framework law, and we can create this complementarity, and this can really help into Brazil pursuing a more strong posture into negotiating the treaty this year or next years as well.
Thank you so much, Andressa. Sorry to rush you. I know we could talk about these issues for ages. I'm going to hand over to our next speaker, Giuseppe, and I think this is going to be really interesting in that we've seen over the past couple of negotiations the EU pushing back on the treaty, and Giuseppe is going to speak to us about corporate sustainability due diligence directive in the EU and its complementarity with the treaty. Giuseppe, sorry, we can't hear you.
Can you hear me now?
We can hear you, thank you.
So, sorry, I was introducing myself. My name is Giuseppe Cioffo. I work for CIDSE. We are the international family of Catholic social justice organizations, and we have been very active over the past years in our advocacy, both on the UN LBI on transnational corporations, as well as on the EU, the upcoming EU law, EU directive on corporate sustainability due diligence, on which I will spend a few words. I think Joseph and Andressa did a very good job of highlighting the importance of the treaty of the LBI, the importance of international binding rules for corporations, and also the insufficiencies of purely due diligence-based approaches that do not take into account the urgency of the needs for, or the need for justice and reparation for victims. So starting a little bit from this point of view, over the next 10 minutes, I wanted to do 3 things. The first one is to give a little bit an overview of what the Corporate Sustainability Due Diligence Directive is, because I think many people in this webinar may be aware and informed about the treaty process, but maybe a little bit less about the EU directive. I will then move on to spell out quite quickly and shortly the differences and the main complementarities that we see between the instruments, and then I will try to make a short argument of why we think that the 2 instruments should work in complementarity and why it's important that the European Union engages in a progressive and victim-centered way in the negotiations for the treaty. So yeah, the first thing that I wanted to do is explain a bit what is the Corporate Sustainability Due Diligence Directive, which is a very complicated file. So I apologize in advance if there are elements that I will skip over or that I will not go into details too much, but we have time for Q&A where we will go more deeply into the topic. It's very hard to give a presentation of the Corporate Sustainability Due Diligence Directive because at the moment we have 3 different versions of the file. We have the Commission proposal that was tabled in February of this year, but we've also, of last year, apologies, but we also have the Parliament's version of the directive, the Parliament's opinion on the directive, and then we have the Council of the EU's version of the directive, which means that the 3 institutions, the Council of the EU, the European Parliament, and the Commission are now negotiating among themselves and trying to find a common approach, a common version of this text. I will therefore refer to the Commission's proposal when I talk about the directive, but I will also bring up where loopholes or gaps could be fixed in one of the other institutions' versions of the text. So what does the CSDD do? The directive, we call it CSDD or CS3D. What does it do? It has 2 objectives. First, to prevent, mitigate, and end the adverse impacts of companies based and operating in Europe, so European companies and foreign companies that operate in the European Union market, to prevent, mitigate, and end the negative impacts of their activities on human rights and the environment. And second, to provide access to justice for those who are affected by the activities of such corporations. So the first objective, the prevention, mitigation, and termination of negative impacts are addressed is through a due diligence duty, to an obligation for the companies covered by the directive to perform due diligence. And the companies that have to perform due diligence are not all companies in the EU or operating in the EU. In the EU are a set of 2 different sets of companies that can be summed up basically in companies with more than 500 employees and with a certain yearly turnover that are based in the EU, and companies of a similar size that are based outside of the EU, as well as companies that have more than 250 employees and they operate in 3 high-risk sectors, which the Commission identifies with agribusiness, garments and textiles, and mining and extractive and the extractive industries. I will not go into details of the due diligence duty in the directive because I think it's more useful to do so in comparison with the draft, with the 3rd revised draft of the UN treaty. I think it's really important to recognize that the Commission in drafting the text did quite an effort in bringing on board voluntary principles that are already there, but at the same time, the text lacks in very important points that misalign it from international standards such as the UN Guiding Principles on Business and Human Rights. For example, the due diligence duty in the Commission proposal does not include a mandatory stakeholder consultation element. It does not include necessarily the specific rights and role on indigenous people when investments concern their traditionally held lands. It does not adopt a gender-sensitive approach in the due diligence duty, and also conceptualizes due diligence as a quite a closed set of measures. So the due diligence duty is basically the way the directive is trying to impose this obligation on companies to prevent, mitigate, and terminate negative impacts on human rights and the environment. And the second point, the access to justice part, is introduced through an article on civil liability. It is really important to understand that the civil liability in the directive is not a civil liability directly for harm. We are not holding companies liable for the harm they have inflicted on human rights on the environment. We are holding them liable if in two cases, if A, they fail to prevent, to mitigate, or to put to an end a negative impact they were carrying out. So a due diligence failure, we are talking about a due diligence failure, a failure to prevent or to mitigate negative impacts. But also, in case that failure causes a harm, the company can be held liable. So we are talking about very specific and very strict criteria for civil liability, a thing with which civil society groups, it's included, have not been very happy with. The directive is very complex instruments, but I think it's important to keep in mind that these are the two main points, the two main axes in which it intervenes. Now, how it compares to the treaty, and before we compare it to the treaty draft, I should say it's really important to keep in mind that we're not comparing pears and apples or oranges and apples, but the two instruments have the same objectives and are at the same time quite different. The European directive is rooted in company law and in competition law, right? It's not a human rights instrument. It's actually a corporate law instrument. The treaty is a human rights instrument. This puts it in a different legislative environment. I will try to address very quickly what the main differences and complementarities are, keeping in mind that I think the most useful way to see the two instruments is not to see it as two legal instruments of the same nature, because they are not. One is it's an EU law instrument, the other is international human rights treaty, but as two different ways to implement the UNGPs, to improve on what's in the UNGPs, and to achieve in the scopes. So in terms of scope, one of the biggest differences that we see right away is that the UN, following the UNGPs, the UN LBI recognizes that all companies have an obligation to respect human rights. And in Article 3.2, the treaty draft also specifies that states may take measures to address different kinds of companies differently. So, of course, a state is not going to regulate a large transnational corporation the same way that a small or medium local enterprise, especially in the global south, could be impacted. This is very important. The European instrument at the same time has a very limited scope. As I have mentioned, more than 500 employees or more than 250 employees. So it is a bit contradictory as well that the European Union, when it has participated in the negotiations, has pushed for an all-company scope, for a scope of the treaty that would cover all companies, while at the same time in their instrument, in their domestic instrument, they are actually doing the same. They are restricting the scope of application quite importantly. I think that's an interesting contradiction because in my view, and I'm curious to see what other things could open compromise on the issue of scope. That's been one of the issues that's been dividing global south and global north states. With regards to the due diligence duty itself, I think the complementarity in this part in particular, I'm talking about Article 6 of the treaty, which is the article that sets out the due diligence duty, and the Article 4 to 9 of the directive diverge, but are also very much complementary. What we see in the treaty is a general due diligence duty. The treaty does not go very much into details in what are the concrete steps that companies have to do, but it highlights that the due diligence duty should be inclusive of stakeholders, inclusive of the rights of indigenous people, of women, human rights defenders, and other vulnerable groups, all specifications that are missing for the Commission text. At the same time, the Commission text is very detailed in terms of due diligence, which in my view, it makes sense because the treaty is addressing a large constituency of states, and it makes sense they would set up a less specific due diligence duty in particular, but then the state would legislate regarding to the characteristics of their companies. I think there is a natural complementarity that we could find there. Where the two instruments are very different, and when we really think that the treaty could supplement the gaps, complement the gaps that are present in the CSDD directive, is the access to justice, rights of victims, and right to remedy parts. So, as I already explained, the CSDD includes a very limited civil liability regime. This is in part, as I have said, because it's been a legislator's intent to frame civil liability in the directive in this way, to give very little avenues for victims to seek liability. At the same time, it is also a matter of EU law, because we have issues such as applicable jurisdiction and choice of law, which are regulated in other European Union's either fundamental treaties or regulation. I'm talking in particular of the Brussels I regulation, and which cannot be regulated in this directive. It is very useful, therefore, that the Treaty on Access to Justice issues and on the rights of victims, and in particular on issues of forum law convenience, forum necessitatis, applicable law, choice of jurisdiction, that the treaty actually gives the victims a choice in this regard, and a choice that, and I join Joseph in his call, a choice in harmonizing or in complementing to the highest standard, right? So we have a minimum standard or insufficient standard that's been put forward by the Corporate Sustainability Due Diligence Directive, a little bit because of political reasons without the European Union, but also a little bit because of the nature of the beast of European law. On the other hand, we have an instrument that's doing away with the concept of forum law convenience, introducing a strong concept of forum necessitatis, giving victims a particular strong sense of right, and also lifting important barriers to justice that have been also one of the main demands for civil society with regards to CSDD, but that unfortunately didn't make it into the Commission's proposal. So to sum up, on scope, duty, and liability, the two instruments are very different because of their different nature, but also could work quite well in tandem. We really hope that in the upcoming negotiations on the directive, the European legislators are going to take the elements from the treaty that are going to strengthen the CSDD, but also there are elements of the CSDD that the EU, if they participate in the negotiations, could bring to the treaty and make it stronger. I'm thinking in particular of two elements. The first one is that the directive includes mandatory human rights and environmental due diligence. The environmental impacts are addressed quite comprehensively in the directive, while, as we all know, there is still debate in the treaty whether the scope of the treaty, the material scope of the treaty, should also cover environmental law and environmental impacts. And then there is another important element, is that the directive improves significantly, I think, on international standards of due diligence by also introducing an obligation for companies to terminate business activities when they are causing harm. The obligation to terminate is not expressed or explicit anywhere in the treaty draft. So to sum up, the issues are quite complex and the instruments are very different. And we hope that by the end of the year, we're going to have a final version of the directive, and this we hope that we'll integrate many of the progressive points of the treaty, but we also hope as civil society that the European Union is taking notice of the important gap that exists in international law, and that a European regional instrument is not enough if we want to close the impunity gap transnationally with regards to TNCs, and that they will engage with a progressive mandate, and this is very important, a progressive mandate in the next session of negotiations. I apologize if I spoke a bit too quickly, but I can end here. Thank you.
Thank you very much, Giuseppe, and a very, very big thank you to all of our speakers. It was incredibly helpful and useful for me particularly, and I'm sure for all of our participants, to hear about your work that you're doing and the insights from your particular regions. I also think that this was really important for our discussion on corporate accountability broadly, to hear about what is happening and what are developing trends in the various regions. I think it's clear from all of our speakers that there is a global shift towards regulating transnational corporations and ensuring accountability for human rights violations, with the development of lots of policies, national action plans, and due diligence directives in a number of regions. I know that the African Commission on Human and People's Rights recently put out a call for the development of regional law in Africa. So we certainly are seeing a shift. And so this conversation is really important to understand how these various developments can be complemented by the treaty. And I particularly liked what you said, Joseph, about different but useful when combined. And what we really saw from Giuseppe and Andres's presentation is that despite there being the development of due diligence directives and national action plans, that there remain gaps. And the treaty can really be a global standard that can fill those gaps and ensure that communities are placed at the center of this conversation and this process and are able to access justice and remedy. I would like to remind everyone to please post your questions in the Q&A box or to raise your hand. And I'm going to hand over now to Elodie to please facilitate the questions.
Hi everyone. So now, as Jessica said, we're going to start with the Q&A. So I've seen that there are already some questions in the box. So thank you very much. And thanks to our speakers who already responded to some of them. So I'll start with the questions in the box. And then, yeah, if you want to speak, just raise your hand. But the first one would be for Giuseppe. Could the treaty process currently be at risk of freezing the current human rights due diligence focused approach to corporate accountability at the cost of more expensive proposals?
Should I go ahead and answer? Okay, so does it risk freezing the human rights due diligence laws and processes that are ongoing? No, I think if anything else, it has boosted them. I think the negotiations for the treaty in Geneva have really made it clear to many lawmakers nationally that business as usual is not an option and that they need to take action to regulate corporations. I think one important thing that the treaty debate is doing, and that civil society and states have been very active in bringing forth at the session, is what Andresa was saying, not that due diligence is not enough. I think what we see in the treaty is really a focus on transitional access to justice and on remedy and rights of victims. And I think these issues are crucial if we want to really address corporate impunity at a global level. So I think it's really important that the discussions are there first to be finalized and to get a treaty that is actually binding and effective international, but also to state that there are issues of transnational justice that are seriously important, and that while due diligence has an important role in prevention, we really need to focus on remedy and the rights of victims and access to justice.
Thanks so much, Giuseppe. So now the next question, it's for Joseph. Given your long-standing engagement with the treaty process, what do you see as the biggest challenge for the process going forward?
Yeah, thanks for the question. We adopt this thinking that this is really a session-by-session approach. No, the fact that we've lasted for 9 sessions already is already, I think, an accomplishment that, as Michael pointed out at the beginning, really the big push from civil society, I think, has driven this process forward. Over the more, there was a survival period at the beginning of the negotiation process where the energy seemed to come more from civil society rather than states. But I think over the last couple of years, and especially at the last session, where we saw very clearly states like Palestine standing up, advancing very progressive positions, that there seems to be a momentum forward. And this is also in the context where I see what is happening at the national level for mandatory due diligence can be a complementary process, as long as it's not the end goal in itself, right? And I mean, to add to Giuseppe's response to that question, I think it's the other way around that is the problem. In fact, if you're looking at the position of the European Union, for example, where they refuse to, well, with their statement at the 8th session was, we are not engaging in direct negotiations, but we direct you to what is happening at the EU level on due diligence. So it's the other way around. It can be if you want due diligence to be the main and only focus, and to as an instrument to move away from the legally binding negotiations, then it can deter that process. But I think over the years, as I said, I'm seeing a lot of momentum, and I think it is crucial. In the last session as well, we saw African states coming out very strongly. So there are those, key milestones, I would say, that is pushing the process forward.
Thank you, Joseph. Now we have some questions for Andressa. In what way do you think the Brazilian framework was influenced by the treaty process, noting that the African Commission recent call for the development of regional law in Africa regulating TNCs? And we also have another one. Do you think that by failing to establish direct human rights obligations on corporations, the future international legal instrument will establish an environment, kind of human rights obligation-free environment for TNCs?
Okay. So the Brazilian framework was mainly influenced by the treaty because we wanted to avoid exactly what Joseph mentioned, that the due diligence discourse came into Brazil in the sense that Brazil went away from the treaty negotiation. So in order to advance this, to come to Brazil and to come to Latin America and say, okay, we are going to develop a due diligence legislation. So we don't need the treaty. We want to avoid that. And we developed the framework legislation to say, okay, we have a framework legislation. It's a good one. And this allows Brazil to negotiate better into the treaty process. So now you have a framework legislation that grants you the possibility of negotiating better, because you don't want other countries to have a lower standard than you do, This is also a competition issue, because you don't want other countries to have a lower standard that you do, especially South countries. So this was strategy thinking. And also about content, we used a lot of our learnings from the negotiation process throughout these years, and a lot of what we developed inside the global campaign, especially what we call the Blue Treaty that the global campaign developed, what would be the ideal treaty that we as civil society wanted, not what is in the draft, but more what we would want it. That links with the second question, that is fundamental to establish obligations directly for TNCs. And in the framework Brazilian law, we establish what we would want for the treaty to do, that is establishing a section for obligations for the states and obligation for TNCs. They are different obligations. They are not the same obligations, of course. The nature of these obligations are different, but there are the possibility of establishing obligations directly for TNCs in the treaty. There is nothing in international law that says it's not possible. There is nothing in international law that says that doing that, TNCs are going to become a subject of international law. That doesn't exist. I saw that Joseph put the link of a document that we did in Global Campaign, argumenting that. It's a very good document. You guys can access that. And that has been done in other conventions, like in UNCTAD against corruption. So it's not like a new thing. It's new for human rights conventions, but that doesn't mean that it hasn't been done before. So I think establishing a section for obligations for TNCs is fundamental, because if we let countries to establish this internally, we are risking to mitigate the force of the treaty because we are not establishing a common standard. So I think, and in the framework Brazilian Convention, we did that. We put common obligations, we put separately obligations, like what would be the obligations for states. There is to fiscalize, to monitor, to prevent, etc., and the obligations for companies. There are different obligations from the state's obligations, of course, but they exist. So this is important learning that we took from the treaty process as well.
Thanks, Andressa. So, we still have a few questions. And so the next one, I think for Joseph, from your perspective, what should be the content of due diligence laws so they are more effective in providing access to justice for victims of the Global South?
Yeah, I think if you look at as I said in my talk, it has to be situated in the context of really in relation to other policies at the national level, including policies that support the agenda of corporations while undermining human rights of communities, right? So I think that's the first thing, that it has to be, that should be premised on, as we put it in the Frontiers document, the primacy of human rights, right? And as Andreas was saying a while ago, a big concern here in due diligence laws is that they become tick boxes, right? So there has to be mechanisms as well in this mandatory due diligence to ensure that this is not a tick box exercise, and that this due diligence does not mean an excuse for liability, right? So I think part of the so the importance of really looking and connecting the due diligence legislation, and I think this is where the complementarity issue also comes in, that it has to be in connection with or in relation to global standards that will be set by the legally binding instrument as well. So it cannot be in isolation. That's my feeling in isolation of those legally binding standards.
Thanks, Joseph. And there's a final question, and then we'll wrap up. And Giuseppe, oh yeah, you came back. If you could answer the last question about what are your views on the exclusion of the financial sector?
Sorry, my connection dropped. We were talking about the directive, right? It's an exclusion that it does not make much sense for a bunch of reasons. The first reason is that, of course, financial institutions, I think, for example, at the mining sector, right? We look at mining projects in Latin America, we have 8 banks based in Canada and Europe that are financing the most of those projects. Those banks are often aware of the risks at which they are put in populations and of the harms that their investments are causing on people who are affected by such extractive processes. Yet, according to the Commission's version of the draft, for example, of the draft directive, they would only have to conduct due diligence when they sign the investment contracts, right? They would not have to conduct due diligence throughout the duration of their investment. And this, of course, is not only misaligned with international standards, it also contradicts the real practices of many large financial institutions who actually do monitor the impacts of their investment already throughout the duration of the same. So it does not make much sense. We know that in the council discussion, states such as France and Ireland have tried really hard to keep the financial sector out of the scope of the directive, or to make it an optional disposition for member states. So it would be up to member states to include or exclude the financial sector at the moment of the transposition of the directive. For us, this is completely misaligned with the objectives of the directive if we really want to prevent human rights abuses as well as access to justice and remedy, provide them to victims. So yeah, I hope that in the last version that it's agreed on by the co-legislators, we will have the full integration of the financial sector in the both due diligence duty as well as the liability provisions.
Thanks, Giuseppe. And we have one final question, and then we'll have to wrap up. It's about how should issues such like foreign non-convenience be dealt with under the treaty. So I know, Joseph, you talked a little bit about it. So this question is really directed to anyone, but perhaps I would think maybe Andressa or Joseph to respond to this.
I'll let the lawyer respond.
Actually, yeah, I do like this. This is my PhD thesis about jurisdiction. Foreign non-convenience is really simple. You just put out a treaty that countries cannot use it, and that is it. But other jurisdiction issues, it's a little bit harder. We do feel like in the treaty we lack mechanisms that we need three things that to strong jurisdiction issues in the treaty. We need to forbid foreign non-convenience. This is the first one. We need to ensure access to justice through jurisdiction. There is what we call forum necessitatis. This is a new doctrine. This is not easy acceptable, but it's getting stronger. This is the idea of a country exerting or getting jurisdiction without any of the normal links or any of the normal or traditional links of jurisdiction that what we would have in private international law. And because of TNCs, I mean, if a TNC operates in a country, although it's supposed to be a different legal person because they use different legal persons and they use different numbers and different registers, they are under the same economic group and they are under the same holding. And if they are under the same holding and they share stocks and they share profits, they should share as well responsibility. So this is another doctrine that is establishing. And another one is international cooperation. If I get a sentence from one country, but I cannot execute that sentence in this country, I should be able to get this sentence executed in another country. And this international cooperation part is really weak in the treaty as well. And this is really important to reinforce because sometimes we do have some private international law treaties about that in specific cases like international kidnap of children, etc. But we should have that for international human rights law as well, because we have some good sentences for or decisions for some group of victims, but they cannot execute the sentences because the company leaves the country and don't let anything there. The companies leave and don't let any money there, etc. That's what happened with Chevron in Ecuador, and they cannot execute the sentence there, and we have to improve cooperation as well. These are the three pillars, more or less, just to say really en passant what about jurisdiction. One thing that I'd like to address just to finalize is I saw one question in Q&A about the action plans, if they are the ineffectiveness is a lack of political will or a problem with the action plans. I think political will is a problem, but I see a problem with action plans themselves, because first, they are not binding. And I always like to say the problem is not they are not binding only, but also I think guiding principles, they have a problem with content. And one big problem is jurisdiction. The guiding principles do not foresee extraterritorial jurisdiction. Actually, they are below international human rights standards of extraterritorial jurisdiction. So this is a problem that we say guiding principles, they are not only a problem because they are not binding. They have problems with content as well. And this is something that the treaty should correct. Just to wrap up and approach the question as well.
Thanks so much, Andressa. And thank you again to all our speakers and to you also for attending the discussion. We hope that you've enjoyed the variety of perspectives in this session. We're really looking forward to continuing this important dialogue with our next webinar that's going to be on the 22nd of August. It will focus on regional perspectives on the treaty and what would a treaty mean around the world and what still needs to be resolved in the draft. And we'll be joined by Commissioner Derso and Arnold Kwesiga. So look out for that invite. And then that webinar will be followed by a final session on the 19th of September, in which experts and practitioners will assess the important element of access to justice that the treaty must provide. So for us as the Resource Center, we will also partner with other organizations to provide daily summaries during the treaty negotiations in October and host our annual blog series closer to the time. So more to come on that. And thanks again for joining us today. Bye-bye.